financial institutions would implement an ongoing security process and institute appropriate governance for the security function, assigning clear and appropriate roles and responsibilities to its board of directors, to its management, and to its employees. Now, what are the standards for these expectations? Well, the FFIEC has outlined its standards in a publication that it put out in its IT handbook, and that is broken down by basically 5 different areas, which are listed on your slide in front of you. These relate to risk assessment, to coming up with a information security strategy, and that's something that the board of directors needs to review on, at a minimum, an annual basis, and I suspect today happens much more frequently. The institution needs to implement that strategy. It needs to test the strategy to see if it works, and then finally it needs to have constant monitoring and updating of what new threats are out there. This whole area is complicated by the very prevalent use of outside vendors. If you think of data going up into the cloud or to some outside vendors, which every single financial institution I would suspect uses, and banks have special responsibilities with respect to the vendors that it uses. I mean, it is as if the institution itself was providing that function. So banks need to be on top of that to monitor their vendors, and this becomes particularly important with respect to data and data security. How do you get your get your hands around this? You want to give us the next slide. This is a reference to the FFIEC's IT handbook, and there's an excellent appendix in that which indicates all of the laws, rules, and guidance which has been provided by the FFIEC member agencies. So, for instance, the OCC has some 26 bulletins and guidance that it's promulgated. So there's literally over 100 different pieces of guidance and literature out there that institutions are required to implement and understand. So I'm going to lead the discussion today. We're going to have a question and answer format today, and so our first question is to Sharon Klein, which is, what are the various risks out there with respect to IT infrastructure and data security, and how does an institution prioritize those risks?
Thanks, Rick. The various risks are external risks, such as advanced persistent threats and malware, nation states, and also hacktivists. Internal threats, loss of laptops and other mobile devices, PDAs, cell phones, et cetera. Everything is smart and has personal or sensitive information potentially on it. The sloppy security, that's also an external threat and an internal threat. Failure to properly destroy data is becoming much more prevalent in the data breaches that we see and respond to. And third-party risks, Rick mentioned the cloud. In order to be able to operate a financial institution, you have to share data. Hopefully your partners have the same level of security and the same dedication to privacy and security that you do, but the chain is only as strong as the weakest link. And so third-party network connections can be unsecure, and the cloud vendors have overseas operations which may or may not be up to snuff with the American regulators. So external, internal, and third-party risks are the kinds of risks that financial institutions will see in this era, the new reality of data breaches, which is not if but when.
Walt, do you have any follow-up on that?
No, I think I would go into how they're accessing the infrastructure, and I think to that point, there's a number of different ways, many different ways If you look at over the past 7 days, U.S. CERT reported for their weekly update, there were 138 new operating system and program vulnerabilities that they've published. All of these different exploits are means that individuals can attack your system. So what I've really done is kind of thought about what are the top 5 individual ways that, you know, your systems can be disrupted or accessed. And one of the most common ways is really the users. Your end users being tricked into installing malware on the system, you know, by unknowingly downloading malicious programs onto the network. These come in a variety of different forms, as you all know, through email attachments. They appear to be coming from trusted parties or peers within the workplace. You also have a lot of websites that have been compromised, and as a result of them accessing the websites or downloading from the websites, they're unknowingly installing malware on your systems. You know, that's kind of the first way. The second way is that we see hackers who have really gained access and allowed to go into the system and alter settings because they've compromised a user, you know, once that malware is installed. They've compromised that user who may have system admin access, and that allows them to alter settings within the operating system. You know, the third piece is really physical access to your computer. Has that computer been lost or stolen? We get reports of lost and stolen laptops on a continuous basis, and shortly thereafter, there's an associated data compromise once someone gets past the security and authentication that's on it. The fourth one is really just password compromise, and that's compromising your password, sharing your password, individuals keeping sloppy records of passwords. You would not be surprised probably of how many individual end users actually maintain files on their own systems, open flat text files as well as contact files named password, and have all of their various access authenticators involved in that. And then ultimately the last item would really be a breach coming from internal with the company. So I think those are the primary means of accessing the system, in addition to more of the external penetration and APTs that Sharon discussed.
So Sharon, how do you plan to reduce these risks that Walt has outlined?
Sharon, still there?
Thank you, Rick. The planning to reduce the risks really goes to sort of the basic blocking and tackling of trying to get together a security management plan. The National Institute of Standards and Technology has outlined its framework for cybersecurity, and I think that's a good starting place, regardless of whether it's external, internal, or third-party risk. And the core framework is starting with identifying and doing good corporate governance for what are your assets, where are your sensitive pieces of financial information, personally identifiable information, who's accountable, who's on that interdisciplinary team if there is a breach, and how do they respond? What is the plan for that response? Protecting the information, developing and implementing the safeguards, and the only way you're going to know how to do that is your risk assessment, which you should be doing, as you indicated, at least annually, and making sure that you document all the things that you are doing in terms of protecting the system and fixing vulnerabilities, detecting the gaps. So once you do your risk assessment, you'll find out from a detection perspective, where are your vulnerabilities? And you need to understand what those things are and fix them promptly. There are some studies that show that known vulnerabilities have sat idle for like 18 months. And so, you know, that is something that the auditors and the regulators are going to give you fines and penalties for, that you've now identified gaps and you haven't either funded or have the right team in place in order to fix those vulnerabilities. So identify, protect, detect, respond, and that involves your incident response team once an event is in play, but also a dry run, perhaps a tabletop exercise, so that everyone understands their roles and responsibilities once that data breach occurs, when it's going to occur, which is after hours or on weekends, Everyone knows their roles and they can execute against the plan. And recovering, being able to mitigate the risk, to have plans for resilience and restoration and redundancy, business continuity plans. And in part of that recovery mode, every time you have a security incident, it's really a process for continuous improvement to evaluate, to respond, and to then implement back into that process best practices so that the institution can be financially responsible and fulfill their duty to the bank and to their customers in terms of keeping financial data safe.
This is Brian Dolan again. For those that joined a little late, we're offering CLE today, and to do that, I'm going to have 4 code words that you have to write down. The first one is right here. It's going to be RISK. That's R-I-S-K, RISK. And then I'll turn it back over to Rick or Sharon.
Okay, Walt, do you have any follow-up on Sharon's comments?
I think just to add to that a little bit, when we talk about what are the some of those risks, the external, the internal, and the third-party risks, and how do we address them, or what are some of the best practices, as I think about, the internal risk with your employees, this is a continued education and awareness that really prevents and prevents theft of laptops, prevents sharing of passwords. It's the enforcement of your existing policies and procedures and things that are in place. You think about the third-party risks, it's really, do you as a company have the contractual ability to go into your third parties to perform annual physical IT audits to ensure that what you have in your contract is actually in place and all functioning as designed? Do you have the ability to do penetration and vulnerability assessments remotely on your third parties? These are pieces that all should be a part of your contractual agreement with those vendors. And as Sharon mentioned, really some of the best practices are developing that playbook and having a cert response, because when you are breached, it's not going to be in the middle of the week. It'll be on a long weekend, a holiday weekend, and you'll need to have that plan in your hand and ready to go. So, developing a cert from beginning to end, including the appropriate individuals from across your organization, it's not just your IT staff. It's your legal staff. It's your HR, your public relations, your legal divisions, and more. So it's working as a team and going into the cert steps and processes, which I think we'll get into here shortly.
And Rick, if I could just add one more thing, I think Walt's analysis is right on in terms of that team. But more what we're seeing as well is both top-down and bottom-up, so that the regulators are insisting that from a board perspective, those executives at the top need to have internal controls that include privacy and security measures and identify the risks from a risk assessment perspective and be able to not only have their employees and independent contractors and third parties aware and document all of the good things on best practices and policies and procedures that are being done in the company, because 69% of breaches are caused by authorized users. So it's really incumbent on every single organization to do that awareness training at the top level of executives, managers, down to the individual staff person and consultant and third party. So everyone is aligned with privacy by design and security by design.
Great. Anything more on planning? Or if not, then why don't we turn over the program to Angelo. Angelo, what do you do once you know that there has been a breach of your network and your data?
Thanks, Rick. The first thing you want to do is you want to assess the nature and the scope of the incident. I don't like to call it a breach until we know exactly what occurred, but identify what information or systems have been compromised, accessed, or misused. The first 24 hours is really critical. I always like to get in there, record the date, the time, secure the area, the evidence, stop the additional loss of information, and identify all the individuals who have personal knowledge of this incident and how it occurred. You want to mobilize your internal response team, and this is something that Walt just mentioned. You want to have that team comprised of IT personnel, physical security, human resources, someone from compliance, someone from communications, and legal. It's important to have someone from legal on there because you want to have the attorney-client privilege protect a lot of the strategic and legal implications of a breach. You want to have an external response team. That's going to include your insurance carrier. If there are any third parties who have indemnification obligations, a PR or a media consultant, any external consultants or service providers, particularly someone who's going to come in and do a root cause analysis, do a gap analysis to determine what went wrong here, how can we fix it. You want to then begin your investigation and your remediation efforts. And these fall, I think, into two categories or two buckets. One is technical mitigation. And this is where you're going to work with forensic consultants to determine the cause, to contain the breach, determine the number of affected customers, where they reside, the personal identifying information that may have been compromised. And again, you want to stop further data loss at this stage. The one caution, there are instances where law enforcement may say, no, let's let this hacker stay in here so that we can track them and try to catch them. My caution on that is the only time you want to allow that is if you are sure that you are going to know exactly where the hacker is, what systems the hacker is compromised, and how you can track them. If you have any doubt that you cannot monitor the hacker's activities, you need to shut it down immediately. You want to address personnel issues. Human resources, that's why they're involved. Was this caused by employee negligence or just an employee who's engaged in wrongdoing? You also then want to do a legal mitigation. On the legal front, you're going to look at indemnification obligations, your notification obligations, and the policies and procedures, including whether or not there are gaps in the policies and procedures that allowed the breach to occur. You then want to, once you gather all the information, you want to determine notification and begin the notification process. One caution is you don't want to get out too far ahead and give the notification before you have the facts in hand and a plan in place. That was an issue that happened with Anthem. They sent out a notification very early on, and I believe they thought they were doing the right thing, but they got criticized by a number of state attorney generals because they didn't give enough information. You want to make sure you have your arms around the information. You want to have a notification that is going to give timely information, but is not going to be used as Exhibit A to the class action complaint that's going to follow. With notification, not only are you notifying your customers, not only are you notifying your insurance carrier, but you're going to need to identify your obligations to notify law enforcement and your regulators. I always, if there's going to be notification, I'm putting the regulators and law enforcement on notice first before I go to the customers or the carrier, because I want them to hear from my organization first and frame the conversation in a sense of this occurred, this is how we have it under control, and this is how we're going to remediate. You want to start to put together a public announcement. What is your response going to be? Who's going to be your spokesperson? Do I need to have a website? You want to set up identity theft monitoring and a toll-free number. That will be included in your notification, but you want to start to get the wheels in motion for that. And typically, if you have a cyber insurance policy, they will have vendors on hand that can help with that. Determine what type of notice you're going to give. Is it going to be by email? Is it going to be a website? Is it going to be by direct mail? You want to have customer service up and running to be able to respond to inquiries. And after all that, you also want to then begin the process to review and determine the adequacy of your security, the response team, your policies and procedures, what training is necessary, almost a lessons learned plan. You want to start to put that together. Through this all, if you take away one thing, when there's a breach, you want to document all the steps that you take, because that is what law enforcement's going to want to know when they come in, and that is what regulators are going to want to know.
Well, Walt, talking about law enforcement, what is your experience with the help that the agencies can provide, and how should you interact with them?
Sure, Rick. I mean, just to follow up on a little bit of what Angelo said, I agree with all of his steps. I think that it's important that you have, number one, you have that CERT program, and I can tell you a little bit more about that, but I think it's important that you have that independent perspective, and that's your third-party forensics, your consultants, and your investigators. So you're getting that individual independent assessment. Now, they will have to work hand-in-hand with your CERT team because your CERT team has all of the systems and the maps and everything down. But, you know, one of the things that Angelo said on the onset of his conversation was that it's an incident, not a breach. And that's very accurate, and that's the first step in any kind of CERT event is really incident detection. So once it's been detected, the first thing they need to do is you really need to validate, in fact, you've been breached. So once you have that validation in hand, you know, all of this is happening very rapidly. So you're engaging, you know, your third parties. You're executing your business continuity plan once it's been validated. But you're also working to isolate and contain those affected systems. And that has to work jointly with both your third parties as well as your IT members of your CERT team. Once it's been isolated and identified, there needs to be that malware analysis, and that's coming up with what is this new version of malware that's been able to compromise your systems. And from that, you're going to develop indicators of compromise. And indicators of compromise are really something that you're going to use once you've got to a point where your systems are ready to be up and running again. And those IOCs will be used to do online monitoring, live monitoring of your system to ensure that it doesn't get re-breached. Again, at this point, you're doing malware eradication. Your forensic analysis is occurring. You know, it's kind of that threat intelligence. And who is this attributed to? It's at that point, once you have that much information, you're contacting the appropriate law enforcement agency. You know, and when you contact them, they're going to want to know all of the steps that you've already taken. So by having that playbook, by having a CERT response document, and having someone document, as everyone here has said today, every step that's occurred as you went through this process, you'll have that in hand. With your third parties, your independent assessors, you're going to have the forensic images of the servers and the laptop or whatever systems are involved, so that can be utilized as any best evidence in the case. All of that's going to have to be communicated to the law enforcement that's there. They're going to want to sit down and interview individuals who are involved. They're going to want to understand more about the system, look at maps. They need to understand your network, something they don't have today. So all of that's going to be where they really need to work hand in hand with your CERT team, your response team, as well as any of the third parties you employ to respond to an incident.
Hey, Rick, this is Brian Dolan again. Before you jump in, I wanted to give that second CLE word. So the first one is risk. The second was data, D-A-T-A, data, and then we'll come back with the others. Thanks, Rick.
Sure. Well, Angelo, continuing on in the breach scenario, I mean, what are the responsibilities of other company personnel, such as directors, officers, and employees?
Sure. Sharon touched on it a little bit. Directors and officers cannot turn a blind eye to data privacy and security. Directors, there's been a number of recent cases, including, you know, Home Depot, Target, Wyndham, where directors are being sued for breach of fiduciary duty of loyalty and duty of care for not overseeing the company's affairs. With respect to data privacy and security, you want to make sure at the board level that they are looking at the duty to protect and the duty to warn. At the board level, you want to have a review and discussion and documentation in the meeting minutes that, you know, the board is aware of the policies and procedures, They're aware of the information security strategy that the organization has in place. They're discussing the resources that are going to be devoted to data privacy and security. They are going to have an annual audit report. They're going to discuss training. Typically, you want to have one committee on your board have the function of data privacy and security, whether that's the audit committee or another special committee that's created. And I always like to see some IT expertise or data privacy expertise at the board table. In terms of resources, you always want to make sure that the company has updated software and security. They're performing the necessary patches. The FTC has had a number of administrative actions, consent decrees that they've entered into for companies that just did not have adequate software or performing software packages that could result in exposure to a data breach, and that's on a duty to protect. On the duty to warn, you need to do assessments to make sure you understand your risks. If it's a publicly traded financial institution or there's a holding company, you need to determine whether or not you want to issue an 8K that talks about a material weakness. You want to have a plan in place for notification to all the stakeholders, customers, regulators, insurance carriers, if in fact there's a breach, and the officers and directors need to be on board with understanding what that plan is.
Okay, and what are the different organizations that impose these duties and obligations?
So I'd like to say there's one uniform rule, but there's not. So you have federal level, and in data privacy, it's very sectoral. So you'll have financial industry regulated by, the OCC, the FDIC, the Federal Trade Commission, the OTS, to some extent, the SEC, and they're going to have rules and regulations. They're going to have best practices for you to follow. The FTC is probably on the forefront of regulating it, and their main jurisdiction is under Section 5 of the FTC Act. They're going to look at what your compliance with not only the representations you make to the public in your privacy policy, but they're going to look at your compliance with the GLB and the safeguard rule, your compliance with state laws and security laws, and they are going to, if you're not in compliance, bring an administrative action. One of the types of administrative actions I've seen recently, and it's a failure that most organizations run into. The privacy policy and your security measures are on the same page when the privacy policy is created. As different personnel come in and there's different changes, privacy policy and your security measures may not be on the same page. And if you're representing one thing and doing another, that's where you're going to run into liability at the FTC level.
Thanks, Angelo. So, Sharon, now that there has been a breach, what are the various consequences associated with that?
Sharon, can we hear you?
There's direct financial impact. The average cost of a data breach in the United States for the financial industry is about $210 per record. And considering that, there are millions and millions of records, do the math, I think Target had 110 million records compromised. That adds up pretty quickly. In fact, in the Target action, in their SEC reports, they indicated that they had spent $61 million in hacking-related expenses, and that, I'm sure, has increased since that report. In terms of lost profit, Target also, in the third quarter of 2013, really got hit with 46% drop in lost profit. So, you know, in direct financial impact, there are what you need to do to remediate the notification that Walt and Angelo has already indicated is fairly expensive, and the root cause analysis and the forensic analysis of what you need to uncover in order to mitigate and to be able to send the data breach notifications to the right individuals. All of this adds up pretty quickly in terms of a data breach response. Additionally, the reputational damage from a data breach is absolutely huge. The reports, especially on the retail side, indicate that 25 to 30% of consumers will not shop at companies that have had a data breach, whether that's online or bricks and mortar companies, because it all comes down to trust. And it's a top of mind issue. It's in the newspapers every day, and people have choices, and they indicate those choices by saying, if you're not protecting my personal information or my credit card information, I need to go elsewhere. So the reputational damage from a customer perspective is a very real cost of a data breach, as well as the direct financial impact to the business. In terms of the lawsuits and the regulatory exposure, Angelo, what are you seeing on that part?
So the lawsuits in regulatory exposure, you know, within 24 hours of these major breaches, there's class actions being filed. Although the class actions have not gone very far because of a lot of the standing issues, the real liability I've seen, the real exposure, especially financial institutions, are going to be on the regulatory side. There's going to be consent decrees, there's going to be memorandums of understanding, there's going to be new audit procedures you're going to have to put in place, and you know, if it's a consent order, it's going to be a public document, and it's going to go back to reputation. So those are the risks. The type of actions that are out there are not just on the federal level. State attorney generals are taking the lead to investigate and impose their own civil monetary penalties. J.P. Morgan Chase just announced a hack back in October. State Attorney General for Connecticut, Attorney General for Illinois are working together to investigate that. So you're also getting lawsuits from your customers. There's a lot of exposure to lawsuits and litigation, and it's also going to result in a diversion of your resources. You're going to be diverting time, effort, and resources to addressing a breach, trying to recover your reputational damage, when those resources could be used to generate and market your business.
Right, just to add on to the J.P. Morgan Chase, I think they've invested $250 million so far and have a staff of 1,000 people that are now focused on privacy and security. So, you know, that's obviously another direct financial cost of doing business in the new normal that, you know, anyone who has regulated sensitive data, such as financial institutions, really need to fund that in order to prevent and mitigate breach.
Is there any way that you can transfer the risks and the consequences of a breach to, say, an insurance company?
The consequences of breach and transferring the risk, the regulators continue to say no. If you're a regulated institution, part of that mandate and charter that financial institutions have is that they need to protect the accounts that individual consumers have entrusted to them. You know, you cannot transfer that through third-party indemnification. You cannot transfer that to insurance. Certainly insurance and indemnification and contractual provisions mandating privacy and security of third parties help in terms of internal controls to protect the assets of the financial institution. But from a reputational perspective, The individual and the entity that's on the line is the regulated financial institution.
And just to add to that a little bit, Rick, on the insurance side, you know, it is I would recommend to all my clients cyber insurance, but there's two types of coverage you're going to primarily see. One is on the D&O side for directors and officers in these derivative suits or breach of fiduciary duty of loyalty or care. And then there's cyber insurance, which deals with the actual breach and the response. So some of the costs of both the director and officer lawsuit and those class actions are going to be borne by the D&O policy. The other costs with response to a breach, including notification, root cause analysis, any identity theft, insurance, sometimes even some fines or penalties can be borne by a cyber insurance policy that is geared just for that. You know, one of the things that clients should look out for are what are the exclusions and what is going to be covered under each individual policy, the D&O policy and the cyber insurance policy. But on the cyber insurance front, the premiums are relatively reasonable, and when you face the risk of, you know, the expenses that a Target had, the expenses that JP Morgan have gone into, the insurance is well worth it.
Great. So, Angelo, can you give us some examples, you know, of the actions taken or the lawsuits that have been brought? I mean, you mentioned one of the issues for plaintiffs is standing. Can you maybe explain that in a little more detail?
Sure. So, on the litigation front, the defense bar has been very good in getting a lot of these cyber breach cases dismissed on a lack of standing. Unless the plaintiff comes in and has identifiable damages that rise above the speculative level, courts have said, no, you don't have standing to sue. And what they found, you know, a lack of standing is where someone says, I'm at a risk of emotional distress. I'm at a risk of identity theft. I was so scared because of this data breach that I had to go out and purchase credit monitoring services. Courts routinely have said, that's not enough. That's not standing under Article 3. You can't bring a claim. What has happened has been some creativity. There are now a number of claims that are based on either a statutory violation that has a statutory penalty. An example is Fair Credit Reporting Act. You know, they have a penalty of $100 per violation. If there's a violation, they say, well, my damages are the statutory penalty. Now, that's currently being reviewed in the Spokio case with the Supreme Court, but that's an example of them trying to manufacture damages through backdoor of a statutory penalty. The other type of case we're seeing is an unjust enrichment claim. I paid you, financial institution, a premium in fees, and the premium was based in part on security that you were going to provide to my account and my information. And you didn't provide that, and therefore the portion of my fees that are attributable to security, you're unjustly enriched, and I'm entitled to recoup that. The third case or type of case that's out there now that we're seeing is new. It's almost a products liability theory, and we're seeing that in the automobile industry. It's with these CAN bus systems. They're remote control systems that can be hacked into using Bluetooth technology. The theory is you have put out a product that is inherently defective because you know it can be hacked. You don't take adequate precautions to prevent hacking, and therefore there's a defective product. I'm entitled to an injunction, and I'm entitled to damages. So those are the three out there on the litigation side. On the FTC side, you know, what they're looking at, they're going to examine, is there adequate security? Are you promising something, some sort of security, and not providing or living up to that promise? Are you providing adequate training to your staff and your employees? One of the most important things to remember is that you can't just do training once and assume that employees are going to continue to know your policies and procedures. When you are working in an organization that handles sensitive data, you're going to become desensitized to it if you're handling it every day. You need to be reminded. Are you changing your policies and getting appropriate consents? Are they retroactively changing? Are you collecting data in a proper manner? These are the things that the FTC is looking at.
And this is Brian Dolan again for the third CLE code word. It's going to be breach. That's B-R-E-A-C-H. First word was risk, second was data, and the third is breach. Thanks, Rick and Angela.
And then, Rick, one other thing, if I could very quickly. The lawsuits are not only against the financial institutions. There are a number of class actions acts that are being brought by financial institutions who are the victim of a data breach or who suffer the consequence of a data breach. And examples of this are Target, Home Depot. In those cases, banks have brought class actions against the retailer for administrative costs, loss of interest and fees arising from a data breach for credit cards that were compromised. And in the Target case, just in December, the court allowed those plaintiffs' classes to go forward as a class, saying that, yeah, Target was negligent and the banks and financial institutions were foreseeable recipients of what the Target was supposed to have done security-wise, and therefore they can proceed on negligence claims to try to collect their damages. And they overcome that standing problem that I talked about for private plaintiffs because they do have identifiable damages in the form of expenses and administrative fees incurred with complying with Visa and MasterCard procedures, issuing new cards, and putting in place customer service to deal with all the calls when these massive data breaches occur.
Well, following up on that, Sharon, can you give us an example of a high-profile incident and what are some of the lessons that were learned?
Sure, Rick. In fact, let me just take Angelo's Target case and talk a little about that. You know, as I'm sure everyone knows by now, the attack was commenced by the insertion of key logging malware into a third-party contractor, actually a heating and air conditioning vendor's system, and through that portal or pathway, they were able to scrape off credit card and other person-identifiable information, and 110 million individuals were compromised. 11 gigabytes of data were stolen. That's amazing, over 19 consecutive days. What's also amazing is in the Target case, the story was actually, broken by the, I think it was Krebs, who was a blogger. And so instead of getting out in front of it, doing your risk assessment, being able to go fix and all those vulnerabilities and compromises, just imagine if you were the Target CEO and now have a report by a blogger that this security incident was alive and essentially compromising your customers' data to the tune of 110 million people. And to Angelo's earlier point, the banks lost $200 million, real money, in reissuing 21.8 million credit cards. So obviously, that spawned, almost 70 class actions, 21 states. The state attorney generals were involved, as Angelo indicated, multi-district litigation that now has resulted in a $10 million settlement of the class actions to provide some relief, if you will, from the distraction of being pounded by lawsuits. Target is now getting control of the situation. And as you may have just heard, are doing a partnership with CVS pharmacies to be able to actually spin out their pharmacy business and focus on retail so they can do a better job at retail and privacy and security of their customers' information. Huge expenses, as I mentioned, $61 million in breach expenses, profits slumped, and $100 million just to move to chip-based red cards or credit cards. So what are the lessons learned from Target? Third-party scrutiny is unbelievably important, and no one actually, knows, or remembers the heating and air conditioning vendor's name. That heating and air conditioning vendor had security software. It was freeware, not commercial grade, and a huge vulnerability. There were actually intrusion detection systems, and Target got alerts on the intrusion detection systems that something was happening and apparently ignored those alerts. So again, that was a failure of communication. Obviously, they thought about security. They paid multi-millions for an intrusion detection system, and then when push came to shove, there was not the coordination of that all-important security incident response team. The action plan was not there, and they suffered huge losses. So I think third-party scrutiny, don't ignore the alarms, have a plan in place, execute the plan. Everybody should know what they need to do, roles and responsibilities to make sure when there's a breach, how to get on top of it before the blogger does and reveal it to the world.
Great. Walt?
I think, out of all of the breaches, and 2014 really brought about a 28% of breaches over the previous year. And one of the things that was most common across many of these breaches, a common trait was how did they get the information, how did they gain access? And a lot of that was determined to involve spear phishing, which involved sending out targeted emails to employees. They were compromising third-party contractors, as we've just heard, all of which gaining access to resources. And, really using these techniques, not state-of-the-art, sophisticated, national state-level malware or zero-day exploits, but simply taking advantage of individual end users. What we further discovered was that a lot of those end users had very basic files, text files, unencrypted files, that they stored their passwords in. So once someone was executed a piece of malware, got it on their system, they had access to the password files in many of these cases. So I think it comes down to, some of this is very common sense here, but there's a couple key pieces that need to happen, and that's that continuing to educate your users on how to properly store their credentials, including password management tools, not storing them in plain text, and of course just enforcing the policies and procedures in all your internal systems. I think there's other good security solutions that can block the downloads of all kinds of executables coming from the web. Most companies use that already. They don't. Sometimes there's always these exception files, and there's ways that they're getting in through that. And then ultimately, automating a lot of the prevention of these threats that is going to try to keep up with, because regardless of the size of your IT department, unless you have the appropriate automation involved, they're never going to keep up with the constant number of vulnerabilities that are published on a weekly basis. So, really what that lesson learned, it doesn't take the most advanced tools to break into even some of the largest corporations on the planet.
Angelo, any thoughts on a major incident you want to discuss?
I mean, just for lessons learned, if you're counseling the board, I would encourage you to look at the Holcomb-Wyndham's case out of New Jersey. There's an opinion that was written in December by Judge Chesler. It talks about directors and officers' treatment of a demand letter claiming a breach of fiduciary duty related to data breaches. Some of the takeaways that you can get from that opinion is that you want to make sure that at the board level there's a discussion of data privacy and security and the resources devoted to it. You want to have a committee with primary oversight of data privacy and security and regular reporting to the board. In Wyndham, that was the responsibility of the audit committee. to Walt's point, you want to have independent consultants come in and do an assessment on an annual basis and then report on material weaknesses or deficiencies at the board level. You want to have a discussion about those deficiencies so that the board is directing their attention to them, and document any remediation that you take in response to those deficiencies, or the reasons why the board determined it was in the best interest for those remediation efforts not to occur. And you want to just make sure at the board level that there is an incident response team. But that would be my lessons learned and takeaways for counseling your board members.
Great. Any questions, Brian?
Before we look for any questions, my last CLE code word for folks still with us looking for it is going to be pepper. So the first word is risk, second word is data, third word is breach, fourth is pepper. I have my email address on the screen. Feel free to email me at my Pepper Hamilton email address, and I can send you the form to fill out. There's also a Q&A button. As I said, I'll put the screen back up to show you that functionality. If you want to send us any questions right now, we're happy to answer them.
Great. While we're waiting for that, I just wanted to, sort of relay something that that Pepper Hamilton has done internally. I mean, obviously, law firms are a repository of an unbelievable amount of sensitive and very valuable information when you start thinking about, merger and acquisition transactions or any kind of litigation. And so that we are very highly sensitive to that, and, recently have required all of our employees to go through some training using, various modules on, identifying, various malware, the spear phishing, that Walt indicated, how to come up with a strong password. So I just think this is one example of, some of the things that our clients should be doing, and that we are very sensitive to, because you can imagine if there was a data breach at a major law firm, what kinds of implications that would have both on clients, liability, all the things that we've just been discussing. Any last words from Sharon or Walt or Angelo?
Actually, Rick, I would like to end with what you began with, which is the government has published a lot of tools, so I would take advantage of those. There are examples of risk assessments out there. There is a document from the OCIE that has some very good questions that could be a take-home test for your organization to be able to understand whether there are gaps in compliance. They really have been very good about, issuing guidances on third-party security and contract negotiations and what is encryption, all of the things that are fundamental to the security and privacy of information. So, you don't have the budget that, JP Morgan Chase has. The government understands that and has been very helpful in publishing documents under their regulatory purview to help businesses, banks, financial institutions get ready for this, and not to just say, I'm overwhelmed and I don't have the budget, I don't know where to start. You have to start somewhere. You have to document it. You can't ignore it, or there are regulatory fines and penalties for willful neglect that are, millions of dollars and also criminal 10 years in jail. So please start if you haven't, and utilize the website that Rick put out there, or email us. We'll be happy to point you in the direction of some good resources.
Great. Angelo, any takeaways?
I mean, if you're going to focus on your data privacy and security, I'd also make sure you focus on destruction and copier machines. A lot of the more recent breaches have come in through printers, copiers. There's been FTC actions brought against entities that had a lease with a copier machine. All the personal identifying information remained in the memory of the copier machine and it was turned back into the leasing entity. It was never wiped clean, so I would make sure as part of your data privacy security policies, procedures, and assessments, you focus on those areas as well.
Great. Walt, any last thoughts?
No, I think we've got it.
Great. Any questions, Brian?
None came in yet, but if any do come in after the fact, I'll be happy to submit them to the speakers here. My email address will work for that as well. And the recording for this webinar will be on Pepper's website at www.pepperlaw.com later today if you needed to catch anything that you might have missed. With that, we're at the full hour. I think we'll be respectful of everyone's time, and we'll call it a day.
Thank you all for attending.
Thanks, everyone.
Thank you.
Thank you.